request Madam Jayanti Shah to give the welcome address.
Good evening, ladies and gentlemen. It is my pleasure to welcome everyone on this virtual platform. We would like to extend a special welcome for our speaker, Mr. Rajendran Raghavan, who will be speaking on mortgage law. We are excited to have you all here to participate in this very special meeting organized by Madras Presidency Lawyers Forum. We could not have pulled off this virtual meeting without hard work dedication of our MPLF team who have worked tirelessly for all our needs. I hope that today's meeting inspires ideas and discussions that can bring about constructive and transforming changes in our fields. Thank you.
Thank you, Madam Jayanti Shah. May I now request Mr. Ravi Sundaram to give the introduction speech about the speaker.
Rajendran Raghavan, advocate, practicing at various courts in Chennai, especially he is a panel advocate for many banks and he practices at DRT court, DRAT court, NCLT and City Civil Court and High Court Major, and he has got an academy on his own, and he has got one son who is also doing fourth year law graduation at Madras School of Excellency. And when you talk about subject, he gets himself fully involved. And he never comes out of it. And as far as the juniors is concerned, he takes more care for the juniors. And if you go to his office, there will be many juniors. After court hours, 1 hour he takes and call people and take session for them how to go about in the various courts. This is kind of a person, a great philanthropist. He does a lot of charitable work also. And now I introduce eminent person, Rajendran Raghavan, to this great audience. Thank you, MPL, for giving the opportunity. Thank you. Over to Rajendran for his speech and lecture.
At the outset, I thank the Madras Presidency Lawyers Forum for having given me an opportunity. At the same time, I would, my brother Ravi Meenakshi Sundaram has made a lot of statements. I don't know whether I stand worthy on that. But as an individual, I like to stand in a way that let us set an example and try to be the best as far as possible. And as he rightly said, I used to discuss with my juniors to the best possible and whatever, because whatever exposure we get, it is gaining the knowledge by reading or by oneself will be 50%. More than that 50%, the fine tuning is only by seeing with the others. And I try to share whatever is that. And I also learn a lot. In fact, my senior, C.T. Mohan, is there, who's been my mentor in many ways in my life, has been there. And so also many of the guides. And I have been lucky with many of the seniors who used to take little interest in wherever I heard. They have always come to me and pointed out, okay, this is a place you've heard and made a change. So I'd like to be. And as regards MPLF at this COVID time, a lot of pandemic and all confusion at this time, a very stable effort of trying to foster most of our advocates together. A very worthy effort, sir. I really congratulate and salute you for this, and let more of us get benefited by that. I'm also beneficiary by watching many of the programs. Though, if at all, if there is any errors today in my lecture, I would like to take a review at a later time and also do that. And today's topic is one which is a little wider one. Because of course, this is a challenge thrown to me as I was making my offer that anytime we could make a lecture. And the law of mortgages is a very good wide topic also. Fine. I would like to go on a cursory note on the law of mortgages, and I would like to come to the point there on the right with regard to a mortgage and the question of a title, which frequently interludes between a mortgage and the other aspects when enforcement of law. Actually, as regards a mortgage, the evolution of this word is a French word which would say that as a mortgage is a debt pledge. Why it was called as a debt pledge was that once mention, people, whenever they talk about a mortgage, they'll say pledge. Pledge of that particular project property, when it's been made immovable property, it has to die. It cannot survive. That's the reason why the French introduced the word of mortgage, the debt pledge. So the debt pledge dies by the time frame where the mortgager either has to pay the money or the mortgagee takes the route for foreclosure and closes mortgage. So it cannot continue. And similarly, there is one more quotation which already says that once a mortgage, always a mortgage. The once a mortgage, always a mortgage is a misnomer in many sense, because a mortgage, it leads to the point that a mortgage will always remain a mortgage. Yes, in one sense, the mortgage will remain as a mortgage till it is closed, or even when there is a subsequent transfer, you gets into the right, would always have to extinguish that previous mortgage and go on. That is the only reason why once a mortgage been given in. Thus, you would see in the mortgage, there are two things which is essential, which is one, a charge over the property. The second, to redeem that. In the failure of the redemption of the charge, the mortgagee goes for the right for the closure, the foreclosure. This foreclosure is a legal process by which a lender attempts to recover the balance of the sum which he has lent. So, for enforcing that, the only method where the mortgager has failed to do make the repayment is to go for the sale. The common law of mortgages, as one finds, it was an interesting article as yesterday only when I went through the Yale Law Journal of 1928, where Sturgis and Clark make that. They say that an ordinary law of mortgage in all intent means conveying a property which can be defeated by the mortgager performing the condition of repayment. What a wonderful way in 1928 they write. It is you convey the property to the mortgagee, but that conveyance is defeated by the right and the duty of the same mortgager by repaying it. So the conveyance is the essence in a mortgage. This same point of the conveyance over the property has been the point of dispute forever. That is the reason why in the end of the topic, I would like to go on to the right of mortgage and the dispute of the title which interludes. Even the Court of Chancery has held that this conditional conveyance is the one which is valid. So in a mortgage, the few things that becomes essential are a debt. There should be an advance for a mortgage, which can be a present or a future one. So an advance by a financial note is one which is essential. Second point is that a person with a title should come in and he should offer the property as a security for that. And the mortgagee, the lender, would take that property as a security. The security is collateral. The first and primary thing is the essential is to the debt. The debt becomes primary, the mortgage becomes collateral, the secondary transaction. That the interest is created only on the land and not on the estate of the person. So as a mortgage, when it has been created, the interest is created on the land, that the security, and the action for pursuance of the recovery of the mortgage would be by way of a recall of the money or for recovery. There can never be a personal element beyond the scope of enforcing the security in a mortgage. In equity, the redemption would always lie with the mortgager. And at the same time, the parallel for the mortgagee is that his right for foreclosure. These are two rights between the parties, which gives lots of rights and duties for both of them. As a mortgager, after paying the money, I become entitled to get back my property. For which, what are the duties which I have to do? I have to do that. As a mortgagee, for having lent the money, he is entitled to get the property or the money, for which what has to be done. This is very well defined into the Transfer of Property Act 1882, which is an act which we are still following. And thanks to the English, the people who have codified law well, it would say that the mortgage under Section 58, which would say that is a transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced by way of loan, an existing or a future debt or a performance or engagement which may give rise to a pecuniary liability. Thus, a transfer, a debt, a principal, money and interest, and the payment secured for the time being, and the scope for the repayment. These are the essential elements in a mortgage. There are different mortgages which is there, which is defined under Section 58, which is the simple mortgage, then the mortgage by conditional sale, the usufructory mortgage, the English mortgage, and the mortgage by memorandum of by deposit of title deeds, which is now very popularly called by the MODT, mortgage of deposit of title deeds, and the anomalous mortgage. The simple mortgage, as one knows, it is a registered document by which we go on. And the second aspect on the mortgage of a conditional sale is that this is a very peculiar aspect where the intention is shown about the mortgage, and also in case the mortgagor fails to comply with his own duty to do that, then the sale would go on. This and the English mortgage have a lot of similarities which would go into that. Even in an English mortgage, there is a certain time and a date by which the mortgagor agrees to pay the money back. If there is no such precondition, the English mortgage would fail. And in Indian context, predominantly the English mortgage is not applied upon. We predominantly go into the simple mortgage or go into the mortgage by deposit of title deeds. And in some very few occasions, the usufructory mortgage. In the usufructory mortgage under Section 58E, the benefits arising out of the mortgage property also inures to the mortgagee till the time the mortgage debt is cleared. The benefits is in lieu with the interest. So where any interest is paid, the benefit has to get back to the mortgagor. These are things. And when we see the usufructory mortgage, this and Section 109, which would deal on the lease, would go little bit on similarities. So that fine tuning at Section 58E and 109 has to be looked into at some other time. Similarly, when we go on for the conditional sale, a lot of important notice has to be made when a mortgage by conditional sale is being made, because an error in the drafting, that is where we as lawyers command a very huge respect, because other people who do a cut, copy, paste and other things, they may just like that cause a very serious error. For example, in a case where the condition stipulated in a mortgage by conditional sale was that the first part of the entire deed was going on as an absolute sale. And at the end, they have stated that by virtue of a time that it could be repaid and brought back. Unfortunately, the person failed in redeeming his property because the word, the absolute sale, was there in the first part. So while drafting a deed of mortgage by conditional sale, it has to be very carefully drafted. Otherwise, the property could go out of the clutches of the mortgagor. Because ultimately, any mortgagor is not interested in giving up his property. He, at the best, tries to sacrifice his rights of the usage or whatever is that, and try to get back the property after what he is satisfied with that. On a redemption of a mortgage, the conditions for redemption of a mortgage is for the mortgagor to pay back. But while paying back, if the mortgagor wants to make and bring somebody else to pay for him, these are conditions where the mortgagee cannot question him and try to stop him. So these are all the peculiar places where, again, I was telling about the right and title, where it comes, the dispute makes it over there. No, sorry, I thought. Okay. So I have forgotten. The right of redemption, when it has to be exercised by the mortgager, he has the right to make the redemption by making good the payment with whatever interest that has been contracted to there. He cannot, while making the right of redemption, make a partial payment and seek for a redemption. The entire redemption is only after making good and satisfying the entire mortgage debt. Similarly, at the other side of the end, for the mortgagee, where any part payment is being made, the mortgagee cannot refuse to receive such part payment in lieu of the partial discharge. And wherever there is any scope of partial severement of the mortgage and release of particular mortgages, then the mortgagor again will have a right to take that portion of the severable mortgage by exercising the right of redemption. Now we get into an important aspect of our mortgage, which will be more convenient in the present practical view, which is the mortgage by deposit the title deed, which is defined under section 58F. This was earlier made as an equitable right. When one makes the point and the word as equitable, then the law of justiciability has a lot of vagueness that comes in. But this equitable right was enshrined under section 58F of the Transfer of Property Act, because in earlier times the cost of a simple mortgage was very huge, and for smaller and minor aspects when a mortgage has to be made in, this was made by a simple deposit of title deeds, which was not registerable. The moment the document of mortgage by the memorandum of deposit of title deeds or the mortgage by deposit of title deeds by a small letter is deposited with the mortgagee, is not registered, it had its own benefits of the cost and by the relationship between the parties. But over the years, it developed a lot of frauds and various other difficulties, since there was no entry to show in the volume 1 of the encumbrances as seen in the registry of the land assurances when we go into the sub-registrar's office and obtain. This memorandum of deposit of title deeds in the earlier period prior to 2004 was not compulsorily registerable, and it was not stamped, and it never attracted and brought over before the eyes of law. So there were many instances where duplicate documents by various methods, or even getting a copy document and doing a transaction for sale and other things have happened, which opened bona fide purchasers into difficulty, and also similarly the mortgagees or the lenders into difficulty. There had been a lot of cases in the criminal angle also onto this. So over the period, lots of recommendations had been to the Law Commission, and finally in 2004 they came with the thing, and they simplified the stamping and the registration laws for the memorandum of deposit of title deeds, by which they fixed a maximum ceiling, which is uniformly in a larger way applied. And in Tamil Nadu, the law is little lighter, but whereas in the state of Rajasthan and Karnataka, the stamping and the registration cost goes up to this sum about 2 lakhs. Whereas in our state, it is about 30,000 rupees where we are restricting it. So this one benefit inures to the benefit of most of the borrowers over there. And the earlier section 58F had restricted this mortgage only to certain notified towns, and now that becomes redundant by the compulsory registration of the deposit of title deeds, and now it becomes compulsorily registered. Now, what would happen if a mortgage by deposit of title deeds is not registered? This is an interesting provision, because at section 17, where any property right beyond the value of 100 is there, has to be registered. But the practice of non-registration of the memorandum of deposit of title deeds, even now after a lot of simplification, continues. On this part also, I'll continue at the latest stage. The mortgager has the various rights which is defined in the part between 60 and 77, and the mortgagee also has rights, both of which, because as we are all into the legal fraternity, I just don't want to expand each and every provision to go into that, because this is where we are having our own thing. The books are there to make that. So the rights, various rights of the mortgagor would acquire is only one to redeem, the other one is to duty is to pay back, and this redemption can be partial. Similar for the mortgagee, the right is for recovery of money and the foreclosure by exercising the right for sale. Here, the mortgagee and the mortgagor have some common rights, like merging more than one mortgage together and going in either for right of redemption or for the right of foreclosure, and going in for partial closure for redemption or partial sale. These are all the rights in common in way both the sides to be exercised. On a priority of a mortgage, always the first mortgagee would have the priority into that. But what happens where a secondary mortgage is being created, he definitely ranks below the first mortgage. But is it so in all the cases? No. Where a second mortgage has been created with the purpose to save the property from a deterioration, and unless otherwise that saving work has not been done, the whole mortgage, even for the first person, would have failed. In such cases, to that extent of that which has been made would be always definitely available for the secondary mortgage. But in all other parlance, the second mortgagee would remain subservient to the first mortgagee. On marshalling of securities under Section 81 and the contribution of debt, mortgage debt under 82, this is a very essential part where we have to see into this, because marshalling of the security will bring in where two or more properties are mortgaged with one person, then it has to be brought over to avoid the multiplicity of the litigations, and also have the prior mortgage and the second mortgage to be properly settled. On the limitation aspect of a mortgage, unless a mortgage is renewed and unless there is a contract to the contrary, generally a mortgage would survive for a period of 12 years as of the present law, except where the mortgages have been created in favor of the state. Where mortgages are created in favor of the state, there the role goes for a period of a 30-year there. Again, contract to contrary would always apply to that. Apologies. The suit for redemption under a mortgage. This is one other further provision where we are going in as a, wherever a party beyond the contract, because when they go with the contract, the terms of the contract binds with them and they act upon that. And where they have a constraint thing, they go for a suit. The suit is a mechanism by which you bring in the third party, that is the court, to intervene to determine on the rights and the duties and for enforcement. This suit for redemption could be filed by a mortgagee when the mortgagor refuses, when he demands of the payment. Normally, the suit for redemption of a mortgage would be called upon by a mortgagee after the lapse of a certain time. But in certain instances where there is a possibility of a deterioration of the mortgage security, there the mortgagee would advance his right to go for the redemption and go for and seek for the redemption. And even under such circumstances when the mortgagor refuses, there also ahead of their time, the mortgagee could enforce upon. And when any payment has been completely paid and discharged, the mortgagee can never have a right to hold back the mortgage property to the. So these are the essential areas at which on a mortgage we stand. And now on the question of what is the way of whether the mortgage has become a matter of a right or a title, I would like to go with a classic case which I personally had and I endured into at the DRT to make it. And it was one of a classical debate which went on in the year of 2011. There in the case, what happened was that the mortgage had, while defining the mortgage in the deed, they had restricted the property by the description. Because what happened was that the property which was purchased in the year of 1996 was developed by the mortgager before mortgaging the property. So there was a building which consisted of about 2,500 square feet on a land of about 1,800 square feet. But the deed of 1996 had mentioned a 600 square feet of a land of a building into that place. And I had a very tough opponent in the other side, being that of senior advocate Mr. T.R. Money into that. And as we could see that they put a lot of effort into that. And they were saying that the mortgage one is void because the property itself was not properly described. And the second thing is that it did not convey any title to the mortgagee, as there was error into that. And by operation of law, the mortgage is not valid, and hence the right which has been pursued by the bank has to be discharged. On the contrary, when it was there, and even the judge had put up posted to me that since the description of the property is erroneous, the secured creditor could very well withdraw the case and rectify the matter and again come back. So to withdraw a case and rectify and come back becomes a tedious thing. So I made a small research and found that there is no case in the Madras High Court to distinguish between the mortgage as a right and the title of a property, which is only subsequent and subservient into a mortgage matter. Then with a lot of research, then I found the Minerva Theatre case in AP High Court reported in 1978, when generally the mortgage which is there is whatever is the development which is in the mortgage definitely accrues for the benefit of the mortgage debt. That is the basic principle. But here is a case, the mortgage deed has described erroneously to make the extent of the building as only 600 square feet, whereas the building there was 2,500 square feet, and which is inseparable. Then in the case, the very same development was discussed in the 1978 AP High Court case, and they went on where the original property was something else and which was developed and theatre was constructed. So the whole description would inure to the mortgagee, and as such, and in the case over there, it was well discussed, and a very wonderful one which I would circulate for those who would come on the mail. I would make that because it's a very lengthy judgment into that, which went in, and the judge of the DRT also went on to make that, yes, mortgage is only a right. Since it is only a right, there can be variations into that. And the second part is that it need not be compulsorily registrable. And the third thing is that whatever is the immovable property, because the immovable property alone is the one which has been brought in, and whatever the immovable property means, the land and whatever has been the changes over the time, the addition or the deletion would always accrue into that. So as such, we would like to have the view that mortgage is only a right, and when it is a right, the compulsory registration is the other aspect which has been touched upon, and very recently by the Supreme Court, it has also held that since it is only a right and it is between the parties concerned, the mere point that a mortgage deed has not been registered will not extinguish the mortgage, because the parties themselves are bound to be on the mortgage by execution of a document. So the registration, the non-registration part of a mortgage deed does not invalidate a mortgage. Probably we will see DRT. Our arguments are over in about a few minutes. In this question, on the question of mortgage, we argued, me and T.R. Manisar's office, we argued for 6 long, lengthy days, and almost every day we had an argument for about 2 hours, because this merely happened by the error by the document writer. Most of the banks, just because if they seek an advocate, the advocate may charge 2,000 or 3,000 rupees on a mortgage due to wit and make it perfect. But if they go to some document writer, they may get it 500 rupees. What he did was that he took the 1996 document, typed the schedule, the property of 1,800 square feet with a building of 800 square feet, 600 square feet built up area. Whereas there is a plan permission for 2,500 square feet, and all those documents have been submitted in the year 2002 or 3. It was there, the documents been submitted. So definitely there was error in the description of the mortgage. So, but for having a very good judge who had the patience to hear at DRT, normally in DRT we don't find such a way to have that, the mortgage would have failed over there. And similarly, as I was telling about the mortgage by conditional sale, where it was in the case of Mumbai High Court, which went on to say that the condition in the first part of the document, which in the year 1980, I'll get my memory into that. In the year 1980, where the entire recital about the mortgage deed would say that by this deed of conditional sale, absolutely, the mortgagor had conveyed the property to the mortgagee. And there are various other clauses which contain the same provision. And in the end of that, there was the condition that the mortgagor assures to make the repayment within the period of 5 years. And where he could not make that, the mortgagee had taken up the thing that it is a conditional sale, and he has absolutely taken it, because the clause on redemption can never be taken out. So at that point of time, the mortgagor challenged the thing, and apart from the point that there was a lapse of time, which cannot be, the mere lapse of time cannot be a ground on which the redemption can be made void, because Justice Rajendran decisions in the year 1964 is very clear. Even if there is a lapse of time, the principle of equity would always be on the side, it weighs on the side of the mortgagor to get back the property. So here, while distinguishing the judgment of 1964 of the Chief Justice Rajendran Gatkar, the Bombay High Court has stated that since there is an absolute conveyance and the mere term which is stated also does not give a binding nature, it is a sale, and for all means it is only a deed of sale. So the mortgage deed may look simple. These fine drafting and finer versions is definitely to be looked at.
Morgan, 1 second.
That is why there is section 69, where the mortgagor is given the time by the court to make the payment even after the lapse of the time in the mortgage deed. Then it would not mean that there is an absolute sale by mortgaging the property. That is why it is there not to defeat the right of the mortgagor. That's what I feel.
Yes, sir,
Rajendran,
Mohan said that is a correct thing. That is what was elaborately made in the judgment of 1964 of Chief Justice Rajendran Gatkar, because there in that particular case there was an instance of a very calculated and the move to defeat the mortgagor's right to redemption. So there, Justice Rajendran Gatkar said that no, that time and nothing, because the deposit into court is also another very effective one which is there. But here was the case where what happened was that because the facts and circumstances of each and every case would also differ. The judgment of the 1980 Bombay High Court judgment was that because the deed of the mortgage, though it just said as a deed of mortgage in the first instance, all the other clauses which were there contained that of a sale.
Sale.
That is why whenever a document is to be interpreted, it is also the decisions of the various courts that the sum and substances and the content of the document shall be the one which will guide the document as of what nature, and not just the mere title of the document. So that was
And
distinguished in the Mumbai High Court.
as far as you are concerned, I feel that there should not be any sale consideration in the mortgage deed. It should specify
Yes.
more of or only of mortgage.
Yes, sir. Yes, sir.
For
Here,
which purpose it has, because many advocates will have that question when people ask them to prepare draft deed. Then there should not be any kind of sale transfer in that process.
correct, sir. No, actually, this question was on a mortgage by conditional sale. So when a mortgage by conditional sale, the mortgagee almost takes the right of the property. Only thing is that the right is till the date the redemption is properly done and the right is extinguished. The right of the mortgagee would be extinguished only by the corresponding duty exercise. But there will be when a right of the mortgage by conditional sale is being effected. Even now, this is a common parlance of late, because where this is not in the norm or the grounds of the bankers or other registrable lenders. But if we see in the common practice in some other places, they do two things. Either they do a deed of conveyance itself, and they are assured to give back property or the payment. How far that would get back, because it will be again reconveyance. Or the other thing is that the mortgage by conditional sale. So this is going on and being in the practice. So the earlier one which we discussed was the mortgage by conditional sale. And wherever in a mortgage, if the word sale is used, then it will definitely attract the stamp duty of a conveyance.
There is one person, Punita. She has. Punita, you can unmute yourself and then put your.
Yes, sir.
After that, we'll go for impression, Rajendran. Then we'll go to
Yes.
question session.
Yes.
Good evening, sir.
Good evening, sister.
Yes, sir. I want some that detail about the partial redemption.
Yes.
That's the one question. And if you mortgage with the bank, as per by mistake, if you do with the conditional sale, whether in between change it to the other mortgage, like equitable mortgage or simple mortgage, whether it is possible after mortgaging with the bank.
Okay. Shall I, for a clarity, shall I take the question and I'll explain it? One is your question is on partial redemption of a mortgage. Hello,
Yeah.
sister. One was your question was on a partial redemption of a mortgage. The other one is on the mortgage, and I was the mortgage with a conditional sale.
Yeah, if you have done by mistake by the conditional sale mortgage, and after that, whether we can shift it to the equitable mortgage or simple mortgage.
Okay. Now I'll make the point for the partial redemption of a mortgage. The partial redemption of a mortgage means whatever is the mortgage that has been contracted, a part of it you make a payment. And then on making such a part of payment, you are asking for a portion of the mortgage security which is there to be severed and taken out. This would be possible only where there is a scope of severability. If the property is one which is not severable, suppose if you have given 4 or 5 properties as a mortgage, and then you pay an X amount which would be to the satisfaction partially, and which could give the scope for the secured creditor, by which a portion, that is out of 4, one of the property could be released. So that is the only scope on a partial redemption. And on the question of the mortgage with a conditional sale, which has been made by error when they have gone for a thing, and they want to make a replacement with an equitable mortgage. At all times between the parties, where any error has been noticed, they can definitely take corrective measures. And here is a point where if they want to make the change, they could either go in for the cancellation of this particular document of the mortgage by conditional sale, and then go in for an execution of the subsequent equitable mortgage.
Thank you, sir.
Yes.
Now we'll go for impression. Manikandan.
Yeah, that was a good introduction session that we had. That too on a late hours of the Sunday. Many of us won't have that. Want to say it was a pleasure of having all of us for the good gathering. May I now request Mr. C.D. Morgan to give the impression, please.
I think Mr. Rajendran Raghavan has, out of his experience and dealing with matters in mortgage, has made a depth study, and he has put forth to us the several mortgages available and the rights available to the mortgagor as well as to the mortgage. And he has given some cases also. For a youngster, I think these matters which have been said by our speaker is enough for an outward reading of the mortgage law. He has several points like marshalling of securities and the question of limitation, and he has very correctly pointed out that the period is 12 years in the case of parties, whereas if it is a state, it is 30 years. And he has also said that a contract to the contrary will apply. So all these things, I think, would place a junior or a person, a fresher, to understand what is a mortgage and where the mortgage is void and where it is not. So I think the speaker has given us a thought of the mortgage law, its being inseparable or separable. All these things, I think, the complete study of the mortgage law. This would be my impression.
May I now request Brother Vignesh. Mr. Vignesh?
Yes, brother. Hello.
Yeah, can I give the impression, please?
No, my senior, Mr. Rajendra Raghavan has given a cursory view of the aspects of mortgage. Probably in another session, he'll be giving another more, furthermore.
I was referring about where there is a jeopardy in, or a property which is having a deterioration. There, the right of redemption is made in advance. Been reported in way back in the Allahabad High Court in 1905 when Bhavani was Yodha. And similarly, on the clog of redemption, which our Justice Chief Justice Rajendran Gatkar was being a doyen on many cases there, which is in Murari Lal was Dev Karan in 1964, 8 SCR. And similarly, where there is a mortgage by conditional sale, Bappu Sami versus Pataya Gounder in AR 1966 Supreme Court 902 has made that where there is a mortgage by conditional sale, revenue mutation should not be permitted.
Yeah, thank you, Brother Rajendran.
And similarly, on a maintainability of a suit where the mortgage is not been registered, it has also been reported in AR 1980 Sikkim 1 in the case of Vishnu Kala versus Vishnu Mai, and it is also being continued in the recent judgment in 2018. I would the other one I would like to place it to Ravi Meenakshi sir and then circulate it.
Yeah, thank you, Brother Rajendran. May I now request Brother Swaprakash to give the impression, please.
Good evening, everybody. Our senior Mr. Rajendra Raghavan has given a cursory view of the mortgage and the aspects of it. It is really a very vast subject, and he has taken much pain in concising it to 40 minutes. I really admire the way you put up the presentation, sir. And regarding the definition of mortgage, you took the strain of going back to the year 1928, and also in recalling the wisdom of the persons coined those words. Really hats off to you for your perseverance and your hard work. And regarding the other aspect you did before the DRT, you did not leave by saying that the case is gone. You had the guts and the stamina to fight against the senior with TR money. Really a great inspiration to all of us that we should not get carried away by the presence of any senior or the presentation of the judge or the view of the judge. Hats off to you, sir, and really it's inspiration to every one of us. And regarding the other aspects, I think we require some more seminars. We look forward for your participation for your presentation. Thank you.
Thank you, our speaker, Mr. Rajendran. It was a very good impression and very good thorough knowledge on this subject as far as concerned. Though the time limit was very short for you, you were able to take us to the entire provisions of the mortgage aspect is concerned. You have thrown light much on those aspects. And you also given a better clarity on how a drafting on the document is to be, and what things to be clearly stated in those documents of mortgage is concerned. And thank all the persons who gave the impression on for the session for the day. And thanks to MLF, Madras Presidency Lawyers Forum, for creating such an opportunity for all the persons to give their share their knowledge on this forum. And last but not the least, I thank all the participants who patiently waited and listened for the session for the day. Normally on Sundays, every one of us will be having a thought of spending our time with the family or with friends. And that being so, we could see a large number of participants here for the Sunday. That goes to the credit of the MPLF as far as the speaker is concerned. I thank once again the participants for participating in the entire session for the day and making it a grand success. Thank you one and all.